Should you change company data and articles of association in a merger? Indonesian law. Yes, in the process of company mergers in Indonesia, changes to company data and articles of association are often required. Here are some reasons and procedures that need to be considered. Changes to company data. Changes to company name. If the merging company wants to change its company name, then changes to the company data need to be made. Changes to organizational structure. Mergers can cause changes to the organizational structure, so changes to the company data need to be made to reflect the new structure. In Indonesia, cooperatives and foundations are both recognized forms of organizations, but they serve different purposes and are governed by different laws. Here's what you need to know. Establishing a foundation. A foundation, or yayasan in Indonesian, is a non-membership legal entity established to achieve specific social, religious, or humanitarian goals. Foundations can be established by individuals or entities, including foreign nationals, and are regulated under Law No. 16 of 2001 on foundations and Law No. 28 of 2004. Cooperatives and foundations. While there's no direct prohibition on cooperatives establishing foundations, Indonesian law doesn't explicitly permit it either. Cooperatives are considered separate entities from foundations, and their primary purpose is to promote the welfare of their members. Indonesia has implemented various trade protectionist measures to support its textile industry, including non-tariff measures. Indonesia has imposed non-tariff measures such as licensing requirements, pre-shipment inspections, and labeling requirements to restrict imports and protect local industries. Local content requirements. The government has introduced local content requirements to promote domestic industries, including textiles. This means that companies are required to use a certain percentage of local materials or components in their products. Import restrictions. Indonesia has restricted imports of certain products, including textiles, through measures such as quotas and import permits. The legal provision of carbon exchange in Indonesia is governed by several regulations. Key regulations. Presidential Regulation No. 98/2021. This regulation establishes the framework for carbon pricing and trading in Indonesia, known as Nilai Ekonomi Karbon, (NHI). Otoritas Jasa Keuangan, OJK, Regulation No. 14/2023. This regulation governs carbon trading through the carbon exchange, outlining procedures for trading, registration, and verification. Ministry of Environment and Forestry Regulation No. 21/2022. This regulation provides guidelines for implementing carbon pricing and trading, including mechanisms for trading and offsetting emissions. Ministry of Energy and Mineral Resources Regulation No. 16/2022. This regulation specifically governs carbon trading in the power generation sector. Carbon trading mechanisms, cap and trade system. This system sets a limit on emissions for certain sectors, allowing companies to trade carbon credits if they exceed or fall below their emission limits.